which brings us to the last of Second Vice Chair Knight's bills that are on the agenda tonight. It's House Bill 5094. It's an act relating to motor and other vehicles, motor vehicle offenses in particular. It grants a judge or magistrate the discretion to impose the requirement of blood and or urine testing on the use of the interlock or ignition interlock system. For those of you who don't know, if you have a drunk driving case, you used to be suspended for 3 months. Now you have an alternative to have a longer imposition on you, but you have an interlock put into your vehicle and you blow into a machine. And if you blow into the machine and it detects alcohol, it kills the ignition. And it tests you along the way, by the way, during the day. So that interlock system is what he seeks to require, that there may be other ways of doing it. So, Jason, the floor is yours.
Thank you, Mr. Chairman. So this bill looks long and complicated, and it's got a lot of moving parts, but essentially it seeks to provide in those DUI cases where the intoxicant is not alcohol but is drugs, the option for the judge to let a person have a hardship license, but instead of having an interlock, which we don't think is going to work because they're not an alcohol person, let's say they're a pills person or something like that, they undergo a kind of a strict regime of testing to ensure that they're clean so they can drive. I have not encountered this problem myself. This bill is actually the brainchild of Senator Archambault on the other side. I agreed to put it in on the House side because he's, anecdotally, he has seen this problem arise where somebody is charged with DUI or refusal. The police report indicates that they were high rather than drunk, and they want to try to take advantage of the hardship license provisions, which we have built into the law, which is safeguarded by an interlock. So this is trying to create a second kind of safeguard for a different kind of drunk driver. In addition, there's a bunch of changes in there to the procedure of DUI and to some sort of legacy pieces of the law that have been around a while that it doesn't really work anymore. For instance, I don't know when somebody put this in, but the law right now says if you're charged with DUI, you're supposed to get a trial within 30 days. And I guess it would be like a dismissal if you don't get it. Nobody pays attention to that. We routinely waive that requirement. In almost 20 years of practice, I've never seen anyone use that as a get out of jail free card, so to speak. So let's just get rid of it. It's a stupid part of the law. And there's a couple other pieces like that. So with that in mind, I'll take questions, but I will note, I know the ACLU put in testimony on this bill. I'm not sure that they got the thrust of what this bill is trying to do, because it's their letter seemed to indicate that they had a different view of what these drug testing requirements would be for. They are there to help the defendant, not to hang up the defendant and create a trap for them.
David.
Representative Knight, is there, I've read through the bill, maybe I missed it. Is there anything that addresses who actually pays or who would pay for the testing? I know that stuff can get pretty expensive. Would that be on the accused defendant, or would that be on the state?
I envision that would be on the accused, and I think that's the way it is with the interlock, and I would see no reason why it would be different.
Any further questions? Anybody on the monitor? No? Okay. That concludes testimony on House Bill 5094.